Can you see it? And then let me
Yeah, that's perfect.
Is it okay? I just want to see.
Yes.
And even the appearance.
Okay, you may just want to increase it to 100% because some of the members use their cell phones, so they're not able to see the finer print.
Yeah, okay, let me see. This is 70, let's see.
Or 80% would be great. Yeah.
Is it okay, 80?
That's perfect.
Okay. Let me see if all the slides are appearing clearly. Yeah. Are you still able to see that I'm scrolling?
Yes, I can see that.
Gershwin, it's Cyril Roberts here. We're trying to solve this Let's audio problem.
Thank you, Mr. Robertson.
She's really gone. Thank you. Bye.
Okay, Mr. Makulubeti, can we exit the screen sharing?
Can I stop sharing now?
Yes, thank you.
Can I exit? You're saying?
Yes, please. We're just
okay,
waiting
let me exit.
For Ms. Litswalo to try her side.
To try hers, yeah. Okay. No, thank you very much for your assistance.
Pleasure. Enjoy. Good afternoon, Ms. Litsuala. Can you hear me? I can, but you're still very faint. Yeah, it's very soft on my side when you speak. Are you able to share your presentation from another computer? Okay.
I guess. This one.
Real, mama. Ba tla mplaisa ka batho ba Northwest. Ba tla le ba tsamaye batho ba feditse, ba tla le ba tsamaye ma.
Yona ga o change diaparo. Duduva, diaparo tsa o seng go fitlha no ya.
O jwang Kenzo?
I get right.
Honorable Mutsamai, good afternoon.
Good afternoon, my brother. I'm in Cape Town. Where are you?
More Northwest, man. I wish you could get around to go on and go propose.
Why did
Well, I'm proposing.
Go hopula, bro.
What time Cape Town?
Oh, man. When I in network.
Come on, like who believe. I got to do well to sing at the moment. Network, yo.
More than 5 million. Oh, my mates.
Kai.
Yakaribwaya.
Oh, eh.
We are live, my brother.
Re tlamehile re itshware re bue sentle ne.
Hey, everyone, Rabatswa.
Yeah. Re batswala. Oh, batswana ke bona ba etsang so. Wena o itumella gore batswana ba nkutsitse.
Eh, man.
Ba nkutsitse ke moXhosa la ke Dodovu ba nkutswa.
Ona le bo Madlamini ba Basotho bo Madlamini ba.
Ke bone maabane go na le bo mogorosi monna ko KZN ke ba ka makala ke re ba mogorosi.
Eh, mona batho ba go.
1, 2, 3, 4, 5. Bela bozanda bela baloka ini ma start ka meeting. Ako sebetsiwe 1, 2, 3, 4, 5.
Honorable Dadu.
My comrade in arms. How are you, my comrade in arms?
Good, thanks. How are you doing?
Very well, I'm okay. I'm happy that I've dealt with the first part of my work. It was too much.
No.
No, that was too much. Man.
No, I saw that. But at least you're done with your report for now. Yes,
and you know, when you are given some work by the organization, you must try your level best to do it to the best of your ability. But I'm happy that part is over now.
Deputy Minister, I see you here as well. Welcome.
Good afternoon. I hope you are not too tired from your rather long NCOP session. Is it not the Honourable Dodovo's fault, wasn't it? Weren't you looking at interventions in the Northwest?
Yes.
Were you listening? Were you following it?
No, I wasn't following, but I'd heard. I know you're from the Northwest, so I'd heard that the issue was that it was the intervention in the Northwest.
Oh, yes.
So I'm just asking politely whether you delayed the meeting of the council.
No.
By raising many issues or wanting lots of explanations.
Nothing. You know, I was taught by Professor Asmal. You remember him? He used to say, when you speak, you must do what is called, and you are a lawyer, you know these things better. Muntu impravo, meaning you must be straight to the point.
Oh, okay.
Yeah, don't move around. Muntu impravo, you must be straight to the point. And when you are given 20 minutes, it must be 20 minutes. When it's 15 minutes, it must be 15 minutes.
Yeah, okay. Just this one thing with Professor Asmal, it's 10 years today that he passed away.
Today.
Today.
May his soul rest in peace.
Yeah.
You remember when I was much younger in 2004, that would be 17 years ago. I was a member of the National Assembly. And then he had just retired from as a Minister of Education. He was then assigned to be the chairperson of the Portfolio Committee on Defense. that is where I worked with him. Very, very well and meticulous, eh?
Yeah, no, great person.
Professor Asman, oh.
But unfortunately, it's issues of age which will come for all of us.
Yeah.
Yeah.
Yeah, members, Deputy Minister, I think it's 3 o'clock. I propose that we
recording
start.
in progress.
Let me welcome all of you to this meeting. I've noticed that we are about 7 on the platform. I suppose other members will join, given that we also moved the time of the meeting, but I think we're sufficient members to proceed. This is also a briefing that we are going to be getting from the Department on the 3 gender-based violence goals. Let me welcome Deputy Minister and all your officials from the department. And just also indicate that this is a very important meeting, as we are aware that the levels of gender-based violence and femicide in this country are amongst the highest in the world, and this has also been acknowledged by the President as a second pandemic. But just in terms of a bit of background, in November 2018, the Presidential Summit Against Gender-Based Violence and Femicide was held. And this also emerged from the hashtag the Total Shutdown movement, and the summit resulted in a declaration which included the following resolutions, namely to fast-track the review of existing laws and policies on gender-based violence, to be victim-centered and ensure all other relevant laws respond to gender-based violence and femicide, implement the recommendations that have been identified from reviews and address legislative gaps, consider creating a regulatory framework for religious institutions to curb sexual abuses and crimes under the guises of religion, revisit and fast-track all outstanding laws and goals that relate to gender-based violence and femicide, including the decriminalization of sex work. And on the 18th of September, the President expressed the country's commitment to address the scourge of gender-based violence and femicide, and announced an emergency response plan to tackle gender-based violence and femicide, which includes strengthening the applicable legal and policy framework, and hence the 3 bills, which are Section 75 bills, which are currently serving before the committee, will also form part of this process. So, honourable members, we will thus receive a briefing on the 3 bills today, being the Criminal Law, Sexual Offences and Related Matters Amendment Bill, the Criminal and Related Matters Amendment Bill, and the Domestic Violence Amendment Bill. And just in terms of procedure, honourable members and Deputy Minister, we will get a briefing on all 3 bills, and thereafter members can then interact and engage on each and every bill. So please, if you have any questions or anything, please hold on to them. Once all 3 presentations are done, I will then look into that interaction. Let me hand over to you, Deputy Minister, then to take us through the 3 bills. Thank you. Deputy Minister.
Thanks, Chairperson, and good afternoon to all the members. There's quite a big departmental delegation led by DDG Calais Pillay, who's the Deputy Director General for Legislative Development, because there's different officials dealing with different bills. So I will be handing over to her to introduce the delegation. Chair, you've to some extent given the background. This is from the Presidential Summit on Gender-Based Violence, where there was an agreement and undertaking by government to review the laws relating to gender-based violence and sexual offences. These are amendments then to the laws. The first, and the officials will go through it in the briefing, but each of them are linked, so it is very much a package. The Sexual Offences, Criminal Law Sexual Offences Amendment Bill is changing some definitions, but predominantly dealing with the National Register of Sex Offenders. I see, as far as I can see from here, that the registrar is here as well, Ms. Ntombi Machila. Then it is the Domestic Violence Act, which is tightening up that as far as sort of domestic violence orders. And then the Criminal Laws Bill, which deals with a number of amendments to bail, to sentencing, to things like that. But Chair, with your permission, if I can hand over to DDG Pillay. Thank you.
Good afternoon, Chairperson, Deputy Minister, and members of the committee. This afternoon, we will be led by Mr. Henk du Preez on the Criminal Law, Sexual Offences and Related Matters Amendment Bill. This bill deals with, among others, the National Register for Sexual Offences. Thereafter, we will deal with the Criminal and Related Matters Amendment Bill. This deals with various amendments dealing with bail and scheduling of offences. This will be led by Ms. Virginia Letswalo. And the final bill will be dealing with amendments to the Domestic Violence Amendment Act, and this will be led by Mr. Mac Makulubete. Also joining us this afternoon from the branch legislative development is Mr. Lean Clark, who was the original drafter of the South African Law Commission report that led to the original enactment of the Domestic Violence Act. And she has a wide range of experience, and she also assisted with this amendment. Chairperson, together with that support team, we hope to provide the committee with the briefing. Thank you, Chairperson.
Thank you. We're in your hands.
Good afternoon, Madam Chair. This is Henk du Preez speaking. I'm working in the legislative development section of the department. I will be dealing with the Criminal Law, Sexual Offences and Related Matters Amendment Bill, and I am going to share my screen with you with your permission.
Are you able to share your screen?
Madam Chair, sorry, I've got a challenge here. There we are. Are you able? Madam Chair, I apologize. For some other reason, I'm being kicked out now. Please excuse me for a minute so that I can try to relaunch the meeting. I really apologize for this. Hopefully you see my screen now, Madam Chair.
Yes, we do. Please continue.
I apologize. Madam Chair, yourself and the Deputy Minister took care of slide 2 for me, so I'm going to jump into slide 3 and then indicate to you that the bill consists of 2 categories of amendments. The first category deals with offences and the reporting duties in respect of the suspected sexual abuse of persons who are vulnerable. And then the second category, as our Deputy Minister indicated to the committee, aims to effect certain amendments to Chapter 6 of the Principal Act. And Chapter 6 of the Principal Act deals with the National Register of Sex Offenders. I would like to indicate to you that although the second category of amendments are a large number of amendments, most of those amendments are consequential in nature. And as referred to by our Deputy Minister, the important provisions dealing with the extension of the ambit of Chapter 6 are actually reflected in the proposed amendment of the definition section contained in Chapter 6. However, if I may, I'm going to proceed to discuss the first category of amendments with the committee. And the first category of the amendments of the bill aim to introduce a new offence of sexual intimidation to protect persons from threats of imminent sexual harm. Those provisions, it's actually clause 2 that must be read with clause 4. We will get to that in a bit more detail in a minute. The first category of amendments also aim to extend the ambit of the offence of incest so as to provide additional protection for children, and that we will find in clause 3, read with clause 20 of the bill. And then finally, the first category also aims to extend, my apologies, the reporting duty of persons who suspect that sexual offences have been or are being committed against persons who are vulnerable. Insofar as the provision or the proposed new provision dealing with sexual intimidation is concerned, I would like to point out to the committee that section 5(2) of the Act, which deals with sexual assault, provides that a person who inspires the belief in another person that he or she will be sexually violated is guilty of an offence of sexual violation. That flows from the common law principle that if you threat someone with violence, you can be convicted of assault, and since sexual assault or sexual violation is then a subcategory of the offence of assault, that provision or that subsection was included in section 5 of the Act. However, Madam Chair, the question was raised why the principle could not be extended to include all other sexual offences. So what clause 2 of our bill aims to do is to delete section 5(2), and then clause 4 aims to replace that principle or that subclause with a new offence with a very wider ambit. Clause 4 therefore aims to introduce a new offence of sexual intimidation in order to prohibit persons from intimidating others into believing that they or a third party being a person in a close relationship with the victim, will be subjected to sexual offences. Clause 12 of the Principal Act criminalizes incest, namely acts of consensual sexual penetration between persons who may not lawfully marry each other. And there the question was raised whether protection should not be afforded to children, not only with regard to sexual penetration, but should it not rather be extended to also include acts of sexual violation. So clause 3 therefore aims to extend the ambit of section 12 to include acts of sexual violation and not only acts of sexual penetration, but only in the case where children are involved. Section 56 of the Principal Act provides that a person may not be convicted of an offence in terms of the incest provision if at the time when the act of sexual penetration was first committed, he or she was below the age of 18 years, and that the other person exercised a power or authority over him or her, or a relationship of trust existed between the two parties. Now, Madam Chair, since the ambit of section 12 will be extended to offer greater protection to children where an act of sexual violation is committed against them, clause 20 therefore aims to amend section 56(4) by replacing the reference to sexual penetration with the sexual act. Now, the term sexual act is defined in section 1 of the Act, and it encompasses both sexual penetration and sexual violation. And the department is of the view that this will ensure that children are afforded the necessary protection. Insofar as reporting duties are concerned, section 54 of the Act deals with the obligation to report to the police the commission of a sexual offence against a child or a person who is mentally disabled. Now, in terms of this section, Madam Chair, a person who has knowledge that the sexual offence was committed against a child must report such knowledge immediately to the police. A person who, on the other hand, has knowledge, reasonable belief, or suspicion that the sexual offence was committed against a person who is mentally disabled must report it immediately to the police. So what clause 19 of the Act in fact aims to achieve is to ensure that the reporting duty is the same in respect of the aforementioned groups, and the clause replaces a reference to children and persons who are mentally disabled with the reference to persons who are vulnerable. That term, persons who are vulnerable, will become clearer later during the presentation, Madam Chair. Madam Chair, sorry, excuse me. I apologize. I think I've got a problem in my throat. The second category of amendments, Madam Chair, deals with the National Register of Sex Offenders. And the National Register for Sex Offenders is established in terms of Chapter 6 of the Principal Act. Section 43 of the Act sets out the objects of the NRSO, which are to protect children and persons who are mentally disabled against sexual offenders by establishing and maintaining a record of persons who have been convicted of sexual offences against children or persons who are mentally disabled. It also aims to inform employers applying for a certificate whether or not the particulars of an employee or even a potential employee are contained in the register, and then informing licensing authorities applying for certificates whether or not the particulars of applicants are contained in the register, and then also informing relevant authorities dealing with fostering, kinship caregiving, temporary safe caregiving, adoption, curatorship, whether the particulars of a specific applicant have been included in the register or not. As I mentioned, Madam Chair, the majority of the proposed amendments in the bill aim to expand the scope of the register to include the particulars of all sex offenders, and not only sex offenders against children and persons who are mentally disabled. Short, Madam Chair, that means that where the ambit of Chapter 6 is restricted at this stage, that only persons who have been convicted of sexual offences against children or persons who are mentally disabled must be included in the register. That will now be extended to provide or require that the particulars of all sex offenders who have been convicted of any type of sexual offence after the implementation of this will have to be included in the National Register for Sex Offenders. The proposed amendments in Chapter 6 also then aim to expand the ambit of Chapter 6 to include other vulnerable persons, namely female persons between the ages of 18 and 25, who primarily find themselves in educational institutions, tertiary education institutions, and in persons with physical, intellectual, or sensory disabilities, and then also persons with mental disabilities, and then persons who are 16 years of age or older, who, for example, receive community-based care and support services. And then finally, the proposed amendments also then aim to increase the period for which a sex offender's particulars must remain on the register before they can be removed. Section 40 defines certain terms for purposes of Chapter 6, and then clause 5, which is a very important provision dealing with the expansion of the ambit of Chapter 6, aims to amend certain definitions in order to extend the ambit of Chapter 6 beyond the persons currently protected, namely children and then persons who are mentally disabled. Now, there are two important new definitions to be included in Chapter Section 40 of the Act, and that is a person who is vulnerable, and that will be defined as reference to children, persons with disabilities, and persons who are being cared for being sheltered in facilities that provide services to victims of crime and females under the age of 25 years, once again, who find themselves in tertiary institution, educational institution. The definition of sexual offence is also important for purposes of Chapter 6. And it's not limited to sexual offences that have been committed children, or going to do a reference to all sexual offences that have been committed after the implementation of the Act. Just briefly, Madam Chair, the consequential amendments are contained in clauses 6 to 12, 14, 15, and 17. Those are merely, as mentioned, consequential amendments where the phrase child or person who is mentally disabled, wherever it appears in those relevant provisions, will be replaced with the term person who is vulnerable in order to ensure that the sections are then aligned to the proposed extension of the Act. We may also at this stage, Madam Chair, maybe just mention to you that clause 10 of the bill aims to introduce two new provisions in the Principal Act. The proposed new section 44 capital B deals with the access to be granted to the National Commissioner of the South African Police Service to the database of the registered. And then the proposed new section 44 capital C will require that the Director General of Home Affairs must inform the registrar in writing whenever a person's change of identity has been formally approved and recognized by the Department of Home Affairs, and then an obligation will be on the registrar to endorse the register accordingly when necessary. And then finally, Madam Chair, section 48 places an obligation on persons who submit applications for fostering, kinship caregiving, temporary safe caregiving, adoption of children, or curatorship to disclose that they have been convicted of sexual offences, if applicable. Section 48, in contrast to the other sections of the chapter, does not criminalize the non-disclosure. And clause 14 then therefore aims to amend section 48 of the Principal Act to use an offence if the non-disclosure of the testimony took place. I thank you, Madam Chair.
Thank you, Mr. Dupree. Ms. Litswalo. Correct. Is it Ms. Litswalo? Ms. Pillay?
Yes, Chairperson, it's Ms. Letswalo. She was having a connection.
Good afternoon. Virginia Letswalo here. I'm sorry for the delay. My name is Virginia Letswalo, and good afternoon, Chairperson, and everybody in attendance. I am going to take the committee through the Criminal and Related Matters Amendment Bill. Can I share my presentation? I flattered my presentation, Chairperson.
Okay, we're not seeing anything on the screen yet.
Okay. Go back there. Yeah. Yeah. And then there's go here, go there. Sure. And then you insert that thing now. Just ask me.
Can you see the presentation now?
Not yet.
No.
Can I request, Gershwin, if you have the presentation?
Give us a second, please.
Okay.
It should be now. You share. You are sharing.
Is it up now?
Presentation, you may. Yes.
Thank you. Thank you. Sorry for the delay. This bill amends 4 pieces of Acts of Parliament. It amends the Magistrates Courts Act, the CPA. It also amends the Superior Courts Act. Now, the purpose of these amendments are to extend the use of intermediaries and audiovisual links to give evidence, to extend the concept of viva voce evidence, to amend the laws regulating the granting of bail in respect of gender-based violence and femicide offences, to ensure the participation of victims of gender-based violence offences in parole proceedings, to bolster the entitlement of the state to appeal an inadequate sentence imposed by a high court, to clarify the offense of assault in the various schedules to the CPA, and to expand the offenses to which minimum sentences applies. Now, the main object of this bill is to promote a victim-centered approach during court proceedings. We will start with the provisions related to the use of intermediaries, audiovisual links, and non-verbal expressions to give evidence. Now, evidence through intermediaries is an effective procedure to protect witnesses or complainants against victimization during court proceedings, but currently this is only available to child witnesses or complainants and only in criminal proceedings. And the use of audiovisual links, on the other hand, ensures the availability of witnesses in court proceedings and also prevents harm to witnesses. Now, in the light of this, the bill amends the CPA in order to enable a witness to give evidence by means of AVL, both from inside and outside the Republic, and also to broaden the circumstances in criminal proceedings where intermediaries may be used. So now, according to the provisions of this bill, a witness who suffers from a physical, psychological, mental, or emotional condition will be able to use an intermediary to testify. This bill also amends the Magistrates Courts Act and the Superior Courts Act to provide for the giving of evidence through intermediaries in civil proceedings, and also to provide for the appointment and the competencies of the intermediaries, as well as the giving of evidence through audiovisual links in civil proceedings. Currently, the CPA makes it possible for a witness with hearing or speech disabilities and a witness under 18 to give evidence using gestures or demonstrations. Now, the bill amends Section 161 of the CPA to enable witnesses with conditions that inhibits their ability to give evidence orally to also be able to use gestures, demonstrations, or other non-verbal expressions to give evidence. We move to the provisions relating to bail. And the following in that regard is proposed. An accused person who is in custody for an offense against a person who is in a domestic relationship with the accused, which we will refer to as a domestic relationship offense in this presentation, or who is in custody for contravening a protection order that was obtained against this accused to protect the victim from the accused, which we will refer to as a protection order offense, may not be released on either police or prosecutor bail. They will have to get bail granted by the court during court hours. Still, with regards to amendments to bail regulations, a prosecutor must provide reasons for not opposing bail in respect of a domestic relationship offense or a protection order offense. The court must consider the views of the victim regarding his or her safety, the disposition of the accused to commit a protection order or a domestic relationship offense, and evidence that the accused has previously committed a domestic relationship offense or a protection order offense while released on bail or under correctional supervision are additional grounds for the refusal to grant bail, which are provided for in the bill. Still on bail provisions, an accused who is charged with a domestic relationship offense or a protection order offense bears the onus of proving to the court that the interest of justice permits his or her release on bail. An accused is obliged to inform the court of protection orders that were issued to protect the victim against him or her, and whether the accused was on correctional supervision or parole at the time of the commission of the offense. The court may issue a Domestic Violence Act protection order against the accused for a domestic relationship offense where there is no such order in place. Now, the bill also provides for additional grounds for the cancellation of bail, which are the contravention of a protection order against the accused to protect the person against whom the offense in question was committed from the accused, and failure by the accused to disclose that he or she was placed under correctional supervision or parole at the time when the offense was allegedly committed. We now move to provisions related to parole. The bill also amends parole provisions that are found in the CPA in order to provide for the participation of victims of domestic relationship offenses in proceedings where the placement of the convicted person on parole or under correctional supervision is considered. And with regards to appeal, Section 316B of the CPA is amended to allow the state to appeal a sentence that was imposed by the higher court in circumstances where grave failure of justice would otherwise result, or where the admin of justice may be brought into disrepute. This is aimed at addressing instances where inadequate sentences have been passed by the High Court. The bill also amends a number of schedules to the CPA in order to expand on the offense of assault when a dangerous wound is inflicted, so as to include more forms of serious assault in the provisions which are related to, or which has a bearing on the arrest without a warrant, on the granting of bail, and on obtaining bodily samples. We move on to provisions that are related to minimum sentences. Here it is the Criminal Law Amendment Act that is being amended. Part 1 of Schedule 2 to this Act provides for life imprisonment. Now, the bill will add the following offenses: murder of a person under the age of 18, death of a victim who was in a domestic relationship with the accused where the death of the victim resulted from sexual abuse, and the bill also adds an offense of attempted murder in circumstances referred to in Part 1. Now, with regards to rape, the amendment will provide legal certainty where the victim is raped more than once by the accused and a co-perpetrator, where such co-perpetrator is not before the court or has not been convicted for the rape, or where the accused has been convicted for more than one rape in the same trial. The amendments also will include rape of a person under the age of 18 years and rape of a person who is or was in a domestic relationship with the accused in Part 1 of Schedule 2. Similar amendments are affected to the offense of compelled rape in Part 1 still. Further, the bill also amends Schedule 2 in order to insert the following offenses in Part 1, which are now currently in Part 3: attempted murder, rape or compelled rape committed in circumstances other than those provided for in Part 1, sexual exploitation of a child or a person who is mentally disabled, or using a child or a person who's mentally disabled for pornographic purposes. Now, these offenses are currently listed in Part 3. They will now move to Part 2, and they will carry a minimum sentence of 15 years with regards to the first offender, 20 years for the second offender, 25 years for third or subsequent offenders. Clause 17 amends Part 3 in order to insert the offense of assault with intent to do grievous bodily harm on a child who is either 16 or 17 years of age, where the difference between the child and the person who has been convicted of the offense is more than 4 years, and also where the victim is or was in a domestic relationship with the accused. And that's the end of my presentation. Thank you.
Thank you very much, Ms. Letswalo, on that presentation. Okay, the next one is Mr. Mokulubete, the Domestic Violence Amendment Bill.
Thank you, Chair, and good afternoon to Chair and members. Can you hear me clearly, Chair?
Yes, we can.
Am I audible, Chair?
Yes, you are.
Yes, thank you. Thank you, Chair. As mentioned, my task is to brief the committee on the Domestic Violence Amendment Bill. It's one of the 3 bills that have been earmarked to deal with the scourge of gender-based violence. And Chair has already talked about the the presidential summit of 2018, which highlighted the need for the review of, amongst others, the Domestic Violence Act of 1998. What we have done, we have tried in the bill to address the practical challenges, the gaps, and the anomalies which have manifested themselves since the Domestic Violence Act was put into operation in 1999. So, Chair, these challenges do render women and children helpless to the violence they experience, and often this happens within the confines of their homes. Now, by way of the object of the bill, Chair, we have highlighted 4 of these, one of which is to optimize the collaboration between the various departments in order to streamline the provisions of services within the existing mandates of these departments. Chair, I can highlight that these departments are the Department of Health and Social Development, the Police, the Department of Justice, Basic Education, Higher Education and Training, and Department of Communication and Digital Technologies. We're also trying to clarify and simplify the roles of all the relevant stakeholders, Chair, by expressly including the services to be rendered. Chair, this I will talk to when I deal with clause 18B that we are introducing in the bill that talks to the directives that must be introduced and gazetted by these various departments. We also seek to enhance the application of the Domestic Violence Act by providing for maximum protection available through a civil process. And finally, Chair, the bill seeks to address the identified gaps or shortcomings which impact on the optimal implementation of the Act. Now, Chair, going through the contents of the bill, I need to talk quickly and then briefly about clause 2, which we are introducing in the bill to delete and amend or insert the various definitions that are set out in section 1 of the Act, so as to facilitate the interpretation of the Act. What we have done, Chair, by way of a quick summary and brief one, the conduct that constitutes domestic violence has now been broadened so as to include sexual harassment, related person abuse, spiritual abuse, elder abuse, coercive behavior, controlling behavior, and exposing a child to domestic violence. Chair, you will remember that the definition of a domestic violence has got various aspects that constitute domestic violence. So we have identified these as the other aspects that must be included as aspects that constitute domestic violence. Furthermore, Chair, we have deleted the definition of stalking, but we are not doing away with this definition, but instead we are incorporating it to form part of the definition of sexual harassment. Chair, clause 3 of the bill introduces 2 sections, mainly section 2A and 2B. In terms of section 2A, Chair, this clause imposes obligations on the functionaries who believe or suspect on reasonable grounds that a child, a person with a disability, or an older person may be a victim of domestic violence, to report such belief or suspicion as prescribed to a social worker or a member of the South African Police. Chair, we have included a definition of a functionary so that it can be clear to everyone as to who we are talking about, and that definition is set out in the last bullet of this slide. Chair, in terms of clause 2B, we are also imposing obligations, this time on the adult person. You'll remember, Chair, in terms of clause 2A, we are imposing obligations on the functionary But this time, in terms of clause 2B, we are imposing obligations on the adult person to report the knowledge, the belief, or suspicion of an act of domestic violence that has been committed against a child, a person with a disability, or an older person. Similarly, Chair, they must report such to a social worker or a member of the South African Police. However, Chair, we have included an important provision in the bill to say that a functionary that we are talking about in clause 2A and an adult person we are talking about in clause 2B, if they do ultimately report an act of domestic violence, but if they do so in good faith, that person or that functionary or that adult person will not be liable civilly or criminally or in terms of a disciplinary action on the basis of making such report. This is the case despite any law or policy or a code of conduct prohibiting the disclosure of personal information. Chair, we are doing this so as to at least encourage people, especially the functionary or an adult person, to be able to make this report without the penalty of civil or criminal liability. And Chair, we have created an offense, particularly in relation to clause B, where an adult person fails to report the abuse that is contemplated in clause 2B. That will be an offense. Chair, the clause 4 talks to the arrest without a warrant. The peace officer is empowered to arrest a respondent where an act of domestic violence which constitute an offense is committed. However, Chair, if an act of domestic violence that has been committed by the respondent contains an element of violence, that peace officer is obliged to arrest the respondent. Chair, the peace officer who has been called to respond to a scene of domestic violence, but who is not a member of the police, must provide the complainant with a prescribed list of accessible shelters and public health establishments. Chair, we are excluding in this regard the South African or the member of the South African Police, because there currently is a section 2 in the Act which provides for the police to provide the complainant with the prescribed list. Chair, clause 5 is intended to insert section 3A in the Act, which empowers the members of the police to enter a private residence for the purposes of interrogating and obtaining a statement from a person who has information regarding an incident of domestic violence. For instance, in a case where there's an element of physical violence, then the member of the police will be entitled in those circumstances to enter the private residence for that purpose of interrogating that person and obtaining a statement from that person. But that member, before entering the premises, Chair, must audibly demand admission to the residence and announce vividly the purpose of which entry to the residence is sought. So, Chair, the member of the police cannot just barge in without notifying the purpose of their entry. However, Chair, it is unavoidable that in some instances there will be resistance. The members of the police will be prevented from entering the premises or the residence for the purpose of obtaining that statement. So we have introduced a clause that will empower the member of the police to overcome resistance by using a reasonable force that is necessary to overcome that resistance. This force may include the breaking of a door or the window of that residence. Chair, clause 6 talks to the application for the protection order. Chair will know that currently this application is being done manually and physically at court. But now we are making provision for the bringing of the application of for protection order electronically. Chair, the application for protection order does not necessarily mean that it must be brought by the complainant themselves, but any other person who has a material interest in the well-being of the complainant will be able to apply for a domestic order protection order, domestic violence protection order on behalf of the complainant. But this must be done with the consent of the complainant. However, the consent is not required if the complainant is under the age of 16 years or is the person who, in the opinion of the court, is unable to provide the required consent. Furthermore, Chair, all the applications for that is being brought must be captured in what we call the integrated electronic repository. This is the repository that has been introduced to capture all the documents that relates to the application for domestic violence protection order. Clause 7 introduces Section 4A into the Act, in terms of which we are making a provision for what we call a domestic violence safety monitoring notice. This notice can be applied for, Chair, by the complainant, where the complainant is sharing a joint residence with the respondent. So what is going to happen is that once the application has been lodged, it will be an application on a form that will be prescribed in the rules. That application will be submitted with the application for a protection order. However, it can be submitted subsequently, that is after the application for a protection order has been submitted, and the complainant can still be able to make a specific or a separate application for this safety monitoring notice. And this notice, if the court grants the application, the notice will require the station commander of the police station within the jurisdiction of the court to assign a member of the police to regularly contact or visit the complainant so as to inquire into the complainant's well-being. However, Chair, there will be instances where the member is prevented from seeing the complainant, and in this instance, the member of the police may use a reasonable force that is necessary to be able to enter the joint residence so as to be able to see and communicate with the respondent in private. And Chair, this notice will be time bound, and after the expiry of the period, the station commander or his or her delegate will have to file a report with the clerk of the court, and that report will have information that will have been prescribed by the regulations. Chair, Clause 9 inserts Section 5A in the Act to empower a court to subpoena a person. So a person can be subpoenaed to testify in court or to produce a book, a document, or any object which appears to the court to be essential to the just decision of the case. So this person, once subpoenaed, must be in attendance at the proceedings and must remain so in attendance until excused by the court. Clause 5B, Chair, talks to the obligations of the electronic service providers to provide the court with information relating to the electronic communication disclosed by the respondent to commit an act of domestic violence against the complainant. Chair, we know these days electronic systems are used, and they can be used to communicate or to disclose information electronically about the complainant. So the court can be able to ask for information from the electronic service communication service provider to provide the court with a certain information that will be required by the court. Chair, clause 5C talks to the obligation of the court of the order, the obligation or the necessity for the court when it is faced with an application for a protection order to ascertain if there are other orders that have been issued against the complainant or the respondent previously by any other court. So if there's an application that is pending, the court can be able to make an order that this application and the new application be dealt with simultaneously. And in this regard, the court can adjourn the matter for the hearing and give directions regarding the notification of parties and the service of documents. Chair, if there is an existing order that has been put in place, the court must record that order on the court file and must, where it issues a protection order or impose any condition or makes any order, the court must ensure that the protection order does not contradict any such existing order. Chair, clause 10 is intended to amend section 6, which deals with the issuing of a final protection order. And we have made the provisions for instances where the respondent does not appear. In essence, Chair, we are beefing up the provisions that were not in existence in the current act, where we are saying, Chair, if the respondent does not appear, and then the court should be able to proceed to hear the matter. And in instances where the court is satisfied, it can issue the protection order. But if the respondent appears to oppose the application for a protection order, the court must proceed to hear the matter. However, in case of a dispute of fact, the court may, on application of any party, adjourn the proceedings so as to afford any of the parties an opportunity to lead or adduce further evidence. Well, Chair, if the respondent appears, but the complainant does not appear, the court must extend the interim protection order and the return date, in which instance the clerk of the court must notify the complainant of the newly extended date. And if the complainant does not appear on the extended date, then the court will be inclined or will be allowed to discharge the interim protection order. However, Chair, if the respondent appears but the complainant does not, or where both parties do not appear on the return date, where the court has not issued an interim protection order, the court may, after due consideration of any evidence previously received, set a new date for the hearing of oral evidence or discharge the matter. Chair, clause 11 establishes the integrated electronic repository. I did talk to this earlier on, in terms of which all the documents relating to the application for a domestic order will be captured by the clerk of the court in the electronic repository. This clause is the actual foundation or the founding clause of the establishment of the integrated electronic repository. Chair, there will be specific documents that will be included in the to be incorporated or captured in the integrated electronic repository, and the regulation will stipulate which of these documents should be incorporated or captured in the repository. Clause 12 broadens the court's powers in relation to protection orders, in terms of which the court can be able to prohibit the respondent from attempting to commit an act of domestic violence, from entering the complainant's workplace or place of study, or to disclose or distribute certain electronic communication. And in certain instances, Chair, the court can refer a respondent to be dealt with in terms of Section 35 of the Prevention of and Treatment for Substance Abuse Act. Clause 13, Chair, talks to the seizure of the firearms, in terms of which the court can make an order that the firearm be seized. And this can happen even if the requirement of the employment of the respondent is that the respondent must be in possession of the firearm. The court can still order that the firearm be seized. Furthermore, Chair, this bullet talks to who can effect or who can serve the protection order, being the clerk of the court, the sheriff, or the peace officer, who will be specifically identified by the court. However, Chair, service of the documents, where the complainant and the respondent share the same residence, must be served by hand on the complainant and the respondent personally. Chair, the court, in terms of clause 9, can make a cost order, and then in that regard, it will look at the conduct of the parties, and if a party acted frivolously, vexatiously, or unreasonably, the court can penalize that party with an order of costs. And furthermore, Chair, the court can make a determination as to who must pay the costs in relation to the service of process of documents or the information that has been obtained from the electronic communication service provider. Chair, in terms of clauses 22 and 23, clause 22 talks to the prosecutor to an extent that the prosecutor cannot withdraw or refuse to prosecute in case of an offense against a person in a domestic relationship involving the infliction of a grievous bodily harm or a dangerous wound on the complainant or the related person. So if the prosecutor refrains or refuses to institute or to withdraw a charge, they must do so after having been authorized by the Director of Public Prosecutions or a designated senior prosecutor. Chair, the clause 23 requires the Director General of the Justice Department to issue the directives that relates to the clerks of the court, in terms of which setting out what must be complied with in relation to the execution of the functions by the clerks of the court in terms of the Domestic Violence Act. And these directives may also provide that the disciplinary steps or proceedings may be instituted against the clerk of the court who fails to comply with the obligation or with the directives. I did mention, Chair, earlier on about clause 18b, which requires the issuing of the directives to regulate the service and the manner in which assistance should be provided to the victims. Chair, this These directives will be issued by the Director Generals of the various departments. The stakeholders that I've talked to, that is the Department of Health, Social Development, Basic Education, Higher Education and Training, as well as Communication and Digital Technologies. Clause 24, Chair, makes provision for the making of further regulations by the Minister. There are currently regulations, or there's this provision that provides for the making of the regulations. We have improved this provision so as to enable the Minister to provide for the financial assistance to be provided by the state to a complainant or a respondent who does not have the means to pay for service fees, and the granting of legal aid at the expense of the state in certain appropriate instances. Chair, the bill also makes consequential amendments to the Criminal Procedure Act, the Firearms Control Act, the Protection from Harassment Act, the Superior Courts Act, and so as to make a reference specifically to the Domestic Violence Act. I must highlight, Chair, we are amending specifically to highlight Section 47 of the Superior Courts Act, in terms of which there's no requirement that the consent of the judge of the High Court or the head of the court or of the Chief Justice is not required in instances where the judge of the Superior Court is subpoenaed to attend the proceedings in court in relation to the Domestic Violence Act. Chair, in conclusion, I just want to mention just there are financial implications in relation to the bill, and this relates to the training on the directives that will have been issued by the various departments and the upgrading of the criminal justice system by the Department of Justice to cater for the integrated electronic repository. However, this, Chair, will be the expenditure that will be used from the existing budget of these various departments. Chair, that concludes my presentation, and thank you very much.
Thank you very, very much, Mr. Mokulubete. Deputy Minister?
Chair, no, that's it. I think it would then be if there's questions from the members.
Okay, now, then let me just thank you very much for these presentations, the 3 presentations. And I think they cover very important amendments. Well, while this might just be only the beginning of our engagement with yourself on the bill, and I'm sure there's a long path that we'll travel together with you. And I also understand that a lot of work has also been done on this bill by the Portfolio Committee in the National Assembly. But be that as it may, I'm going to open it up for honorable members if they have any comments you would like to make, and or if we have any question for clarity. Honorable members. Honorable members, can you hear me? Okay, maybe while honorable members are busy gathering their thoughts, I think, Deputy Minister, I just had some more general questions that I thought were important for us to pose, given that this is our first interaction, and essentially my questions are more of a general kind of nature. But what is very important is that we are also very interested at the end of the day with all legislation would be around the effective implementation of both. And I think in relation to these 3, what is also of interest to us would also be the costing of these goals to ensure that they are effectively implemented, and obviously what are the financial implications for the implementation of these goals. The other matter obviously relates generally to training, and obviously this would be specific training. I see some of the presentations, I think the domestic violence amendment covered some aspects of training, or it alludes to training, but obviously specific training that is needed, and whom will the department engage to ensure, that at the end of the day, people are capacitated so that there's effective implementation of the goal. My other question is whether there are still amendments that the department is of the view that must still be made, especially in relation to ensuring that all three goals are aligned, or these three bills are also aligned to other pieces of legislation. And also in terms of the department's consultation process on the bills, what were the general concerns raised by stakeholders? And in your opinion, have these concerns been incorporated or sufficiently captured in the current version of the bill that is before us as a committee? And obviously, there are other departments that are involved in this process. And have you consulted with all relevant departments that are affected by the bill? And if you can maybe provide us with an overview in terms of any concerns or challenges that they may have, that you may have encountered during these engagements with the relevant departments, and how will these be addressed to ensure the effective implementation of the bill? So that is some of my more general questions. But I see there's Honorable Nkosi and Honorable Bartlett, your hands are raised. Let me start with Honorable Nkosi.
Thank you very much, Honorable Chairperson. Greetings to the Deputy Minister, if I'm not mistaken, and his entourage, and the members of the Select Committee. Chair, one must start by appreciating the presentation made in all of these three bills. It was well informative, and we are glad to get such presentations. My questions, Chair, will be based on the Criminal Law, Sexual Offences and Related Matters Amendment Act Amendment Bill. Chairperson, my first question is that on clause 1, a national register for sexual offenders, slide 11 onwards, has the department considered extending the scope of the NRSO in respect of this? One, include offenders who come into contact with vulnerable persons in situations outside of employment. For example, unpaid positions at associations or clubs. Is the department able to provide information on the NRSO in respect of the following? Number 1, current status and functioning of the RSO. 2, how many sex offenders' names are currently on the database? 3, how accessible is the database to those that have legal right to access it? 4, how much awareness is there of the database? And lastly, how reliable is the information contained on the register? My other question is related to clause 5 on slide 12. Vulnerable persons. How was the age of 25 arrived at? What informs this decision of the age of 25? Should this age not perhaps be set higher? The bill does not recognize the vulnerability of victims of hate crimes, sex workers, LGBT, IQ plus community. Can the department please provide further clarity on
Honorable Nkosi? Honorable Nkosi, we cannot hear you. Keshwani, she's still on the platform. I see her, but
I'll just follow up with the chairperson.
okay. Maybe while she's coming back online, Gershon, while you resolve that, Honorable Bartlett, maybe we could continue with you.
Okay, thank you, Honorable Chair, and also sorry for not opening my video because I also had a challenge with the video, Chair, but I just have a few questions. And thank you to the honorable members. My first question on slide 4, Chair, the use of intermediaries certainly was welcome, but what would be the cost implications of appointing these intermediaries? And then, Chair, on slide 9, we welcome also the fact that the bill seeks to be tough on domestic violence offenders. However, what is the department's view of rehabilitation, but also the capacity of prisoners and prisons to hold these offenders? And then on the domestic violence amendment bill, Chair, I'm not sure, am I too fast or is it okay?
No, we hear you clearly, Honorable Bartlett.
Okay. And then on the domestic violence amendment bill, Chair, Section 75, Clause 3, Slide 5. Section 2A, it states that a functionary must complete a risk assessment report. What would such a report entail, and will training be provided in the completion of these reports, Chair? And then what accountability is there for inadequate or incomplete risk assessment or failure to conduct a risk assessment at all? And then Clause 4, Chair, on Slide 7. Section 3 only obligates peace officers who are not police officers and who are attending to a domestic violence incident to provide information. Why are police officers excluded from this requirement to provide such information, or assistance to the compliant? Chair, and the last one, Clause 7 on Slide 10. The introduction of domestic violence safety monitoring notice placed significantly more obligations on subs. It is critical that subs has adequate capacity. Now, Chair, what training and costs are envisaged for implementation of the safety notices? I thank you very much, Chair.
Thank you very much, Honorable Bartlett. Is Honorable Nkosi back with us? Honorable Dodo?
Yes. Thank you very much, Honorable Chair. Let us welcome the presentations. In my view, they continue to be very much helpful and informative. And how I just wish that all of us were just complying and ensuring that we vehemently fight the scourge of gender-based violence and it gets ended, especially as it is perpetuated in the main by patriarchy in our society. Just some few points. The first one, what is called the sexual intimidation. What are the, whether do I call them elements, or what are the kind of examples which would constitute sexual intimidation, so that it becomes very clear under what circumstances are this happening, and how can we ensure that they are dealt with. The second point, relates to, broadly, generally speaking, I don't know at what level, but I think our society need continuous education. Education meaning in terms of educating the public generally about their rights and what needs to be done, and educating the public about the fact that if you commit this and that will constitute sexual offenses, and people must at all times try to avoid this. For me, I think this must be continuous, and it must be embedded in what we do on continuous basis, ensuring that we proliferate education to our society in general. For me, that is quite important. The last one, I didn't see it, or maybe I didn't hear it. What if a person lies and there's nothing that has happened in the way, whether it's me, man, as a man, I want to score certain points, and I go and lay a charge against a woman in relation to any of the three bills that are before us. What happens? What is the recourse in terms of lying and knowingly that this has not happened to me, and I, as the dove, I go and open up the case, and later I withdraw it, and having allowed another person to go such excruciating process, which could have been avoided at all cost. With that, I'm okay. Thank you, Chair. Those are my questions.
Thank you very much, Honorable Bodily. Honorable Nkosi, I'm told you're back on the platform.
Yeah, thank you very much.
Honorable Nkosi, we cannot hear you clearly. Honorable Nkosi? Okay, is it just me, or are we all struggling to hear her?
I also can't hear her, Chair.
Okay.
Yes, Chair, I contacted her. She's having some network problems, unfortunately.
It is. Okay. I think maybe then with some of the questions, Deputy Minister, I'm sure we can also perhaps provide it to yourselves as well in writing. Honorable Nkosi? Okay, I see she's unmuted, but we don't hear her. If she had any other questions.
Can you hear me now, Chair?
Oh, yes, we can. Please continue.
Yeah, on clause 19, slide 8, Chair. I wanted to check with the department. Has the department considered aligning the wording of clause 19, amending section 54 on the SOMA with the wording of clause 3 of the Domestic Violence Amendment Bill, which also deals with the obligation to report by an adult person who knows, believes, or suspects on reasonable grounds, and which specifies that the report must be made in a prescribed form and must set out the reasons for such knowledge, belief, or suspicion. How will it be established or proved that a person had knowledge, belief, or suspicion that the offense was committed? Thank you, Chairperson.
Thank you very much, Honorable Nkosi. I think I don't see any other member raising their hand and or interjecting, but I think be that as it may, let me then hand over to yourself, Deputy Minister. Although I note the one, okay, yeah, let me just hand over to yourself, and you can then perhaps take us through some of the responses. If you also feel that you want to give us more detailed clarity in writing, please also feel free to do that. Deputy Minister?
All right, thanks very much, Chair. Look, I think the officials can answer some of the more the detail, the costing of the bills, the training issues. Just to say though, on training, that we do have Justice College for officials of government public service, and then there's the South African Judicial Education Institute for the judicial officers. They can also speak about the alignment of other legislation. On the issue of the stakeholders, again, I think the officials should speak about it, but these bills were put out for public comment at the beginning of last year by the department. It then got caught up in the middle of COVID. We were asked to extend that period. Then as a result of the comments, there were amendments made to the bills, and the bills were then submitted to Cabinet. So please remember that this is not a bill from Justice, this is a bill from Cabinet. So all Cabinet agreed to the introduction of these bills. The Portfolio Committee did address the issue, and again, the officials can give more detail of the implementability of the bill, and there were meetings that they'd had with calling in the SAPs in particular, and the and other departments. Then just on the issue of the NRSO, I think it's Honourable Nkosi's points, and again, others can add on this. The existing provisions in the Sexual Offences Act is that if you have committed a sexual offence against a child or a person with a mental disability, and it is so ordered by the court, your name goes on to the National Register of Sex Offenders. And people who are going to be employed to look after children and people with mental disabilities have to have their names checked against the register. What we're doing in this amendment bill is now to extend it, and we're extending it on two levels. The one is that if it's any sexual offence that you get convicted of, your name goes onto the register. That's number one. So it's not just limited to children and people with mental disabilities. Number two is then one obviously wants to broaden the scope of employment. And it's effectively people looking after, well, we've got this issue of a vulnerable person, and it's a woman under the age of 25. That's largely, and it's again people working with vulnerable people. I mean, it's issues of looking at where is the vulnerability. So the issue is basically if a person is, if a young woman, a 18-year-old, because a child is a person under the age of 18, an 18-year-old, a 19-year-old has left school and is now at a woman's residence at a tertiary institution, they would expect that the people, or they should expect that the people that are employed by that institution in that residence have been vetted because they're vulnerable in that residence. It's less vulnerable for if you're working in a shop because the chances of getting sexually assaulted or raped in a public place are less. So it is an issue of a judgment call. The one thing we did look at and felt that we couldn't do was to say that no person with a sexual offence can be employed, because that would then, what's going to happen to them, after they've served their sentences. So there were submissions from LGBTI groups about being included in the vulnerable person category, and we actually had a meeting with them and with some of the organizations. And the issue is that, yes, LGBTIQ plus people are vulnerable. But in this context, on what basis would you, any sexual offenses in, it doesn't matter who you committed against. On what basis or what context are you working with is a person working with LGBTI people? We had suggested the issue of shelters, which I think has been partially covered. But anyway, I think there was general consensus from the people we met of not to include that they are vulnerable, but in terms of what's needed from this bill, there's not specific categories of employment. My own view is that it's limited to employment because how else do you restrict contact? That's sort of an area. The intermediaries also, I think it's children and people with mental disabilities can apply or can testify through an intermediary. We're extending it. Obviously, that would mean more intermediaries. So I think the officials would have to respond on the issue of the increased costs of that. On Honourable Bartlett's question, other questions on the issue of rehabilitation and the capacity of correctional services to accommodate. Look, that's a valid question, and there are numerous debates. For example, is it worth sentencing somebody to a term of imprisonment of less than a particular period? Because if you're sentenced for less than 6 months or a year, you've probably got no chance of undergoing any rehabilitative program. So should those people be sent to jail, or should it be a longer sentence or not going to jail? But, we have the pressure from the public of increasing the number of offences for which there are minimum sentences. We've got, as people would have seen, the issue of people who've committed crime and who are now liable for parole, and family members of the deceased, the victims, saying they don't want them out on parole, even though they are starting to qualify or they qualify to be considered for parole now. So it's quite a difficult issue. I mean, obviously rehabilitation is very important, but there's also pressure to emphasize the seriousness of those cases more. Then on Honourable Dodovu's question, sexual intimidation. I mean, the one that was sort of raised with me was the question of somebody, as it sort of happened, a taxi conductor in a taxi threatening to rape a woman. That's sexual intimidation. The issue of lies, well, yes, it does happen, but if you make an affidavit and you've sworn that this is the truth, then you are subject to penalties if you retract that, if you've said you've been lying about it. I think, Chair, let me leave it like that for now, and I think if the officials can answer the other questions. I think, as you've said, if officials want to, or if the department want to do a more detailed written submissions or written responses, I think that would also be good. But can I hand it over then to the officials and to Ms. Pillay to lead?
Ms. Pillay.
Thank you, Chairperson, and thank you, Deputy Minister. I think I will start with Henk and request that he refer to those specific questions related to clauses of the bill insofar as the sexual offences, and we'll take that order in terms of the responses. Thank you, Chairperson.
Thank you, Madam Chair. Madam Chair, with regard to the question that was raised in connection with clause 1, extending the scope to include persons outside employment, I think the Deputy Minister has covered that for us. This is something that we will discuss with the committee during the committee's deliberations, but at this stage, we would like just to possibly indicate to the committee that the intention with the National Register of Sex Offenders is preventative in nature. And sorry, Madam Chair, can you hear me?
Not very clearly. I'm not sure if it's just myself, but perhaps I'm not sure. Could you perhaps?
I'm on full volume, Madam Chair. Can you hear me now?
Yes, I think I do. Yeah. Please continue.
Thank you, Madam Chair. Madam Chair, and I think the registrar of the National Register for Sex Offenders is still on the forum. There were 3 questions that were raised, which I think she would be better placed to answer, and that is how many sex offenders have been included, or the particulars of sex offenders have been included in the register, and then also a short description of access to the database of the MSRO. And the third question in that regard was how reliable is that database. So with your permission, Madam Chair, I would rather like to, well, I'm not in a position to answer those questions, so I would prefer if you would allow the registrar to answer that. The only other issue that I need to indicate to you, the Deputy Minister also answered the questions relating to sexual intimidation, and then also the question relating to false charges. I could possibly just indicate to you, Madam Chair, at this stage, and it will become clear to the committee when the committee deliberates on the bill, that the proposed new offence of sexual intimidation includes reference to all the sexual offences that are contained in the Principal Act. So and our Principal Act is divided into general offences and then also offences that may be committed against children and persons who are mentally disabled. The offence can also be committed not only against the complainant directly, but through a person who is in a close relationship with the complainant. For example, where a person threatens the complainant that his or her child or a family member will be subjected to sexual offences. Insofar as the consultation process is concerned, the question raised by the chairperson and the concerns that were raised, we could categorically state at this stage, Madam Chair, that we have consulted extensively. There was also a task team initially that gave rise to the first and second drafts of the bills, and that task team was chaired by our Deputy Minister, if I remember correctly, and there were members of NGOs and the community represented on that task team. But if I may, in a nutshell, just indicate to the chairperson that the most common concern originally was with regard to the ambit of the MSRO, to the extent that, and we will get to that during our deliberations, we will point that out to the committee. But the concern was that the net is thrown too wide, especially when we talk about requirements of access to children. But that is a technical aspect that we will clarify for you during our deliberations, Madam Chair. Madam Chair, with your permission, I would like to ask the registrar of the MSRO to maybe provide you with more information with regard to the three questions that were raised. Thank you, Chair.
Thank you. Is it Mr. Machida from the registrar?
Yes, Chairperson, it's a Miss Machila.
Apologies.
No problem. Good afternoon, Chair and all honorable members, Deputy Minister. I will start with the question on the accessibility of the register. Currently, the register is held in a confidential manner, but it is accessible in a prescribed format, which means we have opened the accessibility to 5 categories of persons, which are employers, employees, licensing authorities, relevant authorities, as well as people who are currently existing in the register can apply to view whether or not their details appear in the register or on behalf of another person. And in terms of how many offenders are currently listed in the register, we've got 30,270 confirmed sex offenders. and 4,773 flagged offenders. When we say it is flagged offenders, we mean that their cases are currently on the roll or they have been finalized, but we are waiting for final documentation in order to include or confirm them to make them active. And the last question is on the reliability of the database. The database, it's very reliable because we take in that it is updated daily. As and when a conviction is made or is passed by the court, the court clerk will then record that into the database, which we